Hold it. Don't move. Step away from that door and keep your hands where I can see them.
All right, my hands are right here, but this is my driveway. What exactly is the problem?
We received a tip connected to this address. Right now, we need to verify your immigration status.
My immigration status? You got to be kidding me.
Sir, I'm not here to debate it. Just answer the question.
I'll ask one question first. Do you have a warrant to be here?
That's not necessary right now.
Actually, it is, because you're standing on my property making accusations.
Listen carefully. We're conducting a federal investigation.
Then you should also know something else. I'm the police chief in this town.
Police chief? Right.
Yes, police chief. Now, I'll ask again. Do you have a warrant?
Doesn't matter. You're coming with us until we sort this out.
Not without the paperwork. You know the rules as well as I do.
Two ICE agents thought they had a routine address check. They had a tip, anonymous, unverified, the kind of lead that arrives through a channel nobody is required to document and nobody is required to question. They had the address. They had the specific confidence that accumulates in people who have operated in a space where the balance of power runs so consistently in one direction that the possibility of it running the other way stops feeling like a variable worth accounting for. They pulled into the driveway of 4412 Sycamore Ridge Drive in Fresno, California at 8:45 a.m. on a Sunday morning in March 2026. Two agents in dark tactical gear marked Police ICE, a white government SUV parked at the curb, the suburban quiet of a residential street on a weekend morning, doing nothing to signal that what was about to happen in the next 11 minutes would end both of their careers, produce a federal civil rights lawsuit with a settlement figure that broke California ICE enforcement records, and generate ring camera footage that the Department of Justice would eventually cite in a formal policy review as a case study in what warrantless enforcement at a private residence looks like when the resident is someone the agents had no business approaching without paperwork. The man who answered the door was not who they were looking for. He was never who they were looking for. He was Elijah Brooks, standing in his own doorway in a crisp white dress shirt and dark slacks, a coffee cup in his right hand, the particular composed stillness of a man who had been awake since 6 and had been preparing for a morning that had nothing to do with what was currently walking up his driveway. He was in his late 30s, clean-shaven, with the direct, unhurried expression of someone whose professional life had trained him to read situations completely before responding to them. The expression that the ring camera on his front porch captured from the moment the door opened, time-stamped 2026-0315 at 8:45:20 in the wide-angle clarity of a Cam 3 front porch feed that had been recording since the government SUV slowed at the curb. He was not an undocumented immigrant. He was not a person of interest in any active federal investigation. He was not anyone whose name appeared on any warrant, administrative order, or enforcement document that Benjamin Carter or Daniel Fletcher had in their possession that morning, because they had no warrant. They had an address, an anonymous tip, and the institutional momentum of two agents who had arrived at a private residence on a Sunday morning without the legal foundation that the Fourth Amendment required them to have before crossing the threshold of anyone's property line with enforcement intent. What Elijah Brooks was, the thing that Benjamin Carter registered first on the doorstep and that Daniel Fletcher's expression confirmed he had also registered, in the specific way that information registers when it arrives after a decision has already been made and the decision cannot be immediately reversed, was the chief of police of Fresno's East Side District. 14 years on the force, the youngest district chief in the department's history, a law enforcement career that had produced 2 commendations, 1 use of force policy revision that bore his name in the department's internal records, and a working relationship with the FBI's regional field office that meant his phone had the direct line of the special agent in charge saved under a first name. He looked at the 2 agents on his driveway. He looked at the gear. He looked at the SUV at the curb. He took 1 measured sip of his coffee. Then he asked them, in the tone of someone who already knew the answer and needed them to say it out loud for the camera, whether they had a warrant. They did not. What happened in the next 11 minutes, recorded in wide-angle clarity by a ring camera that Elijah Brooks had installed 8 months earlier and that had never recorded anything more consequential than a delivery driver, would be reviewed by the FBI, the California Attorney General's Office, the Department of Justice Civil Rights Division, and the Fresno Police Department's command structure before the morning was over. The settlement that followed would be the largest individual payout in California ICE enforcement history. The careers of Benjamin Carter and Daniel Fletcher would not survive the month. Some driveways you do not walk up without a warrant. This one had a camera, and the man in the doorway had the Attorney General's number in his phone. Before we go any further, if this story already has your attention, share it right now with someone who needs to see it. Drop your city in the comments below, hit that like button, subscribe to this channel, and smash that notification bell so you never miss a story like this one, because we post them every week and every single one of them matters. Elijah Brooks had lived at 47 Oakwood Drive for 19 years. He had moved in at 16 when his family relocated from South Central Los Angeles to Fresno's East Side corridor in the specific, purposeful way that families move when they have decided that a different environment is a non-negotiable requirement for what comes next. He had grown up in that house, done homework at the kitchen table, learned to drive on the residential streets outside, left for college from the same front door that Benjamin Carter and Daniel Fletcher would walk up to 19 years later without a warrant on a Sunday morning in March. He had come back to that house as a police officer, then as a detective, then as the youngest district chief in the Fresno Police Department's recorded history, an appointment that the department's commissioner had described at the ceremony as the result of 14 years of work that had consistently produced more than the rank preceding it asked for. The FBI National Academy had been his 33rd year, 10 weeks in Quantico, the same program that produced chiefs, superintendents, and federal agency leads from 40 countries, the program that his department had nominated him for because his file contained the specific combination of field performance and leadership capacity that the academy was designed to develop into something institutional rather than individual. He had graduated in the top 15% of his cohort. The certificate was framed in his office at the district station. The methodology was built into every policy decision he had made in the 2 years since. 14 years of service, FBI Academy certified, 19 years at the same address on Oakwood Drive, an address that was in every department record, every personnel file, and every public directory available to any federal agency that had done 30 seconds of database work before loading into a government SUV on a Sunday morning. The database work had not been done. The SUV had come anyway. Benjamin Carter had been with ICE for 6 years. In those 6 years, he had generated 19 complaints. Not in aggregate across a division or a field office, 19 complaints attached to his name specifically, filed by 19 different individuals across the Fresno metropolitan area, each one documenting an enforcement contact that the complainant described in terms that varied in vocabulary but not in substance: wrong address, no warrant, insufficient basis, stopped without cause. The language changed from complaint to complaint the way handwriting changes from person to person, different on the surface, identical underneath. The statistical analysis that Sarah Clarkson's, that Elijah Brooks's attorney commissioned during discovery, would become the most cited document in the subsequent DOJ review. It was 4 pages long and required no editorial interpretation because the numbers carried their own argument without assistance. Of Carter's documented enforcement contacts over 6 years, 83% had involved individuals who were Black, Hispanic, or Asian American. Of those contacts, 61% had been initiated on the basis of anonymous tips that were never verified before the contact was made. Of the 19 complaints, 0 had resulted in formal disciplinary action. 0 had been cross-referenced with each other during any review process. Each had been assessed individually, resolved individually, and filed in a folder that no supervisor had ever been required to read from beginning to end. 19 complaints, 6 years, 0 pattern findings. Daniel Fletcher had been Carter's partner for 14 months. His complaint record was shorter, 7 complaints, the same vocabulary, the same demographic distribution, the same individual resolution pathway that prevented the 7 from ever becoming a sequence that required a different kind of response. He had learned in 14 months beside Carter that the absence of consequence was its own form of instruction. Both of them had learned the wrong lesson. The ring camera on the front porch of 47 Oakwood Drive was about to teach them the right one, in wide-angle clarity, time-stamped, with no interpretive room and no folder available to file it in individually. The anonymous tip had come from a burner phone. That detail, unremarkable at the time of the call, logged in the standard format that dispatch used for unverified tips and filed without the additional scrutiny that a verified source would have triggered, became the thread that the FBI's Forensic Communications Unit pulled on 11 days after the Sunday morning on Oakwood Drive. It took them 4 hours to trace the number to a prepaid device purchased at a Walgreens on Clement Street in Fresno on a Thursday afternoon 3 days before the call. The store's security camera had recorded the purchase. The face in the footage belonged to Richard Davenport. He lived at number 53 Oakwood Drive, directly across the street from Elijah Brooks. Davenport was 51 years old and had lived on Oakwood Drive for 6 years, 2 years less than the length of time he had been filing complaints, grievances, and formal objections with every municipal body available to him about matters that the receiving institutions had each independently characterized in their response letters using variations of the same phrase, without sufficient basis. His HOA complaint record ran to 14 entries. He had filed 3 noise complaints against the Brooks residents in 4 years, all 3 reviewed, all 3 closed without action because the investigating officer on each occasion had found no evidence of the noise described. He had submitted a written objection to the Eastside District's community policing initiative that Elijah Brooks had designed and implemented, an objection that cited no specific policy concern and had been acknowledged and filed without response. 6 years of petty grievances, 14 HOA complaints, 3 noise complaints, One anonymous tip to a federal enforcement agency, placed from a burner phone purchased 3 days in advance, describing an undocumented individual at an address that contained a 14-year law enforcement veteran whose personnel file was publicly accessible to any federal database that had bothered to check. Davenport had not expected the FBI to trace the call. He had not expected that the purchase of a prepaid phone at a Walgreens on a Thursday afternoon would become a federal evidence exhibit by the following month. He had expected, based on 6 years of filing complaints that produced no consequence for him and no relief for anyone else, that this one would work the same way. It did not. The grab happened at 08:47:11. Cam 3 recorded it with the wide-angle precision of a front porch camera that had been installed to capture package deliveries and had never been asked to document anything more consequential than a delivery driver's signature. It captured everything in the same frame. Elijah Brooks in the doorway, coffee cup in his right hand, the door partially open behind him. Carter on the driveway, one step closer than the conversation required. Fletcher positioned slightly behind and to the left, the geometry of a two-person approach that experienced enforcement officers use when they want the subject to feel surrounded before the word surrounded has been used. Elijah had asked for the warrant at 08:46:03. Carter had told him they didn't need one. Elijah had told him, in the same level tone he had maintained since the door opened, that the Fourth Amendment disagreed, and that no ICE agent had the authority to detain a citizen at a private residence without either a judicial warrant or consent, and that consent was not being given. He cited the statute the way Brooks had cited Terry v. Ohio, not as performance, but as information, delivered in the flat, factual register of someone for whom the legal standard was institutional knowledge rather than research. Carter reached for his arm at 08:47:11. The contact lasted 4 seconds. 4 seconds of Carter's hand closing around Elijah's left forearm, the one not holding the coffee, and pulling with the specific downward pressure of someone attempting to move a person from a doorway without their cooperation. The Cam 3 footage captured the motion from above and to the left, the angle that showed Carter's hand position, Elijah's response, and the coffee cup that remained level throughout, held steady by a man whose composure did not register the grab as a reason to spill anything. Federal battery, committed at a private residence without a warrant, on a Ring camera, against a district police chief who had the FBI field office's direct line in his phone and was already calculating in the 4 seconds Carter's hand was on his arm exactly how many calls needed to be made before 9 a.m. He made the first one at 08:48:33. 42 seconds after the grab, while Carter was still on his driveway. Deputy Chief Sandra Morrison arrived at 47 Oakwood Drive at 08:54 a.m. She had been 11 minutes from the address when Elijah's call came through, not on the department's dispatch channel, not through the standard communication infrastructure that Sunday morning patrol traffic ran on, but directly to her personal cell phone, which meant she understood before he finished the first sentence that what was happening on his driveway was not a situation that needed to be routed through normal channels. It needed her, specifically, immediately, with the authority that her rank carried and the institutional knowledge of someone who had worked alongside Elijah Brooks for 9 of his 14 years and understood exactly what the call meant when he described 2 ICE agents on his property without a warrant. She arrived in her personal vehicle, plain clothes, badge visible on her hip. She stepped out with the specific contained energy of someone who has assessed a situation remotely and is now arriving to confirm what the assessment already told her. Carter and Fletcher were still on the driveway. Morrison looked at them the way experienced law enforcement looks at a scene that has already produced its own verdict before anyone has said anything, reading the geometry, the body language, the timestamp on the Ring camera display visible through the open door, and the expression on Elijah Brooks's face that told her everything about the 11 minutes she had missed. She identified herself by rank and name. Then she told Carter and Fletcher in the flat institutional tone that senior officers use when they want every word to be remembered accurately, that they were standing on private property without a judicial warrant, that the contact they had made with the resident constituted federal battery under 18 U.S.C. Section 242, and that the driveway they were currently occupying was now a federal crime scene. She said it once. She did not repeat it. Then she called the FBI field office from the same driveway, with Carter and Fletcher still on it, and told the duty supervisor that she needed an evidence preservation team at 47 Oakwood Drive by 0900 a.m. because the Ring camera footage currently recording from Cam 3 front porch contained documentation of a federal civil rights violation that was going to require the kind of institutional response that did not benefit from waiting until Monday. Carter looked at Fletcher. Fletcher looked at the camera housing above the door. Neither of them spoke. The lesson that Morrison's arrival delivered in the space of 4 minutes was the one that the driveway had been building toward since the government SUV slowed at the curb. That the speed of institutional accountability is determined by who makes the first call and how quickly the right people answer it. Elijah had made the call at 08:48. Morrison had answered it before he finished the sentence. The FBI duty supervisor answered hers on the second ring. By 9 a.m., 3 separate federal and law enforcement institutions knew what had happened on that driveway. Carter and Fletcher had arrived with an anonymous tip and left with a federal crime scene. The distance between those two outcomes was 11 minutes of Ring camera footage and 1 deputy chief who drove 11 minutes without stopping. The federal trial began on a Tuesday morning in October. Carter and Daniel Fletcher had been charged under 18 U.S.C. Section 242, deprivation of rights under color of law, and under a supplementary charge of conspiracy to commit civil rights violations that the DOJ had added 6 weeks after the initial indictment, when the Forensic Communications Unit confirmed the burner phone trace and established that Carter had received and acted on an unverified anonymous tip without conducting any database verification before loading into the government SUV. The database check that would have returned Elijah Brooks's name, rank, address, and 14-year service record in 11 seconds had not been performed. The prosecution entered the absence of that check into the record as its own exhibit, not what Carter had found, but what he had chosen not to look for. Elijah Brooks testified on the third day. He arrived in full dress uniform, the complete formal presentation of a district police chief, every commendation in its correct position, the FBI National Academy insignia visible on his left breast, the specific institutional weight of 14 years of law enforcement service worn on his body in the format his rank required. He sat in the witness chair with the composed, direct attention he had maintained since the door opened on a Sunday morning in March, and answered every question in the same level, unhurried tone that the Ring camera had recorded from the beginning. The prosecutor asked him to describe the moment Carter reached for his arm. Elijah described it, precise, sequential, the timestamp, the contact, the 4 seconds, the coffee cup that had remained level throughout because nothing about what Carter did had produced in him a response that required the coffee cup to move. Then the prosecutor asked him what Carter had said when Elijah identified himself as a law enforcement officer and district chief. Elijah looked at the jury. He said Carter had looked at his badge, looked at his face, and said 5 words that the Ring camera's audio had captured in the kind of clarity that made the court reporter's job straightforward and the defense attorney's job considerably less so. That's what they all say. The courtroom was quiet for a moment in the specific way that courtrooms go quiet when something has been said that everyone present understands has just decided something. The defense attorney did not object. There was nothing to object to. The audio exhibit was already in evidence. The jury had heard the recording. Elijah's testimony had simply confirmed what the camera had already established, that Carter had been told, clearly and with credentials visible, exactly who he was grabbing, and had responded with the 5 words of a man whose 19 prior complaints had taught him that identity, credential, and rank were obstacles to be dismissed rather than information to be processed. The jury deliberated for 3 hours, guilty on all counts, both of them. The civil settlement was reached 14 days after the guilty verdict, $9.7 million, the largest individual payout in California ICE enforcement history, entered into the public record with the specific permanence of a figure that becomes a reference point for every subsequent civil rights lawsuit filed against federal enforcement agencies in the state. The number was not the story. The number was the evidence that the story had been taken seriously by the people with the authority to put a price on what had happened on a driveway on a Sunday morning in March, and that the price they had arrived at communicated in the only language that institutional behavior consistently responds to, that the anonymous tip, the missing database check, and the 5 words after the badge was shown were not an acceptable operational standard. Carter was sentenced to 31 months in federal prison. Fletcher received 18. The sentencing judge's written statement addressed the "That's What They All Say" audio exhibit directly, noting that the phrase demonstrated not a mistake made under pressure, but a disposition formed before the driveway, carried on to the property, and applied to a credential that should have ended the encounter before the grab. The disposition, the judge wrote, was the offense. The grab was its expression. Both sentences were served in full. The Brooks Bills, 3 pieces of California state legislation named after Elijah Brooks and passed within 8 months of the settlement, required judicial warrant verification before any federal immigration enforcement contact at a private residence, mandatory database checks completed and documented before any field contact initiated on the basis of an anonymous tip, and a cumulative complaint review protocol for all federal enforcement officers operating within California jurisdiction after 2 complaints within a 24-month period. The third bill was the one that Elijah had testified in support of before the state legislature in July, in full dress uniform, same composed tone, same level attention, and that had passed with the kind of bipartisan margin that legislation produces when the ring camera footage has already made the argument and the legislators have watched it.
Richard Davenport pleaded guilty to filing a false federal report and making a materially false statement to a federal agency. He was sentenced to 14 months probation and 200 hours of community service. His HOA complaint file was entered into evidence during the plea proceedings, all 14 entries read into the record in sequence, producing in the courtroom the specific cumulative effect that sequences produce when they are finally allowed to be read as what they are, rather than what each individual entry appeared to be in isolation. He had lived across the street from Elijah Brooks for 6 years. He had filed complaints, grievances, and objections with 14 different institutions over 6 years and had never once produced a consequence for anyone except himself. The burner phone was entered into evidence as Exhibit 7. It is currently in a federal evidence storage facility in Sacramento, in a sealed bag with a chain of custody document attached, in the same condition it was in when the Walgreens security camera recorded its purchase on a Thursday afternoon by a man who had not expected the FBI to trace it and had not expected that a ring camera installed to monitor package deliveries would become the most consequential piece of documentation produced in the largest individual ICE civil rights settlement in California history. Elijah Brooks returned to the East Side District on the Monday following the sentencing. Same office, same desk. The FBI National Academy certificate was still on the wall. The direct line to the field office special agent in charge was still saved under a first name in his phone. He had a full week's docket and a department that had been running in his absence with the specific institutional resilience of an organization whose chief had built it to function without requiring his constant presence. He made coffee at 6 a.m. He was at his desk by 6:15. The work continued. If this story held you from the first timestamp on Cam 3 to the last sentence of the sentencing judge's written statement, if it made you think about what a database check costs versus what skipping it costs, about what 5 words captured on audio can do in a federal courtroom, about what happens when the ring camera has been running since before the government SUV slowed at the curb, share it with someone who needs to see it. Stories like Elijah Brooks's exist because a front porch camera was recording and a deputy chief answered her phone before the first sentence was finished.
We tell them because the people whose doors get knocked on without warrants and whose names don't come back as district chiefs when the database is finally checked deserve the same outcome and the same legislation. If you want more stories about federal accountability, civil rights enforcement, and the moments when the system was forced to answer for what it built, hit that like button right now, subscribe to this channel, and smash that notification bell so you never miss a video. We post stories exposing racial profiling, federal misconduct, and the people who made the institution read its own file. Every story is documented, every one matters, and the camera is always running.